People State of Michigan versus Lynn Michael Prentice Senior appearance in the record.
Good afternoon, Andrew Valencourt, of the people.
Mr. Prentice, please stand up and address the court with your name.
Glenn Michael on behalf of the estate of Glenn Michael Prentice Senior.
All right, we're here for the exam. How we proceed?
People are ready to proceed.
All right, any preliminary matters?
A few different things. Number one, I would ask for a mutual secret arbitration order. I have my officer Charles seated with me and my first witness, who is behind me. My second witness is seated out in the hall. But I would note for the record that the defendant has a number of folks here with him today. I don't know if they are potential witnesses at all to this case.
That's why I'm gonna ask him to leave the courtroom. I don't know Mr. Prentice. I don't know how, if it goes to circuit court, how this case will play out. If you all stay here in your testimony, you cannot testify at circuit court if he needs you at circuit court. He doesn't have an attorney. I don't know how this is gonna turn out, but even if he gets an attorney in circuit court, if your name is on this record in your testimony, it will be shared with that judge and you can't testify. So I would ask everyone to leave. And then Mr. Prentice, if you need somebody from the hallway and you're gonna call witnesses, then you can bring them in, because I just don't know how you're gonna proceed with this case. All right, so everyone can leave, so we can start the exam.
Not sure that I comprehend what you're explaining. If we stay here, we cannot do what.
So if you stay here in your testimony, it goes to circuit court, you cannot take the stand if he goes to trial. So I don't know who y'all are. He's not an attorney. I don't have a witness list. I don't have anything. So I'm trying to protect him if he wants to go to trial on the next level, because I'm gonna give all your names to the circuit court judge. It's gonna be in this record. And if Mr. Valencourt, if you go to trial and you try to take the stand, for example, your name is Stan Smith, Mr. Valencourt will be like, nope, Stan Smith heard testimony at the exam, so he's barred from testifying. And that could prejudice him at trial. So I'm saying it's best if you all leave, because just in case if he needs you at circuit court, he won't be barred from testifying. Get what I'm saying? So I don't know where a court officer is, but I'm gonna ask everyone to leave. Because like I said, I don't know what he's gonna do at the circuit court level. He doesn't have an attorney. And I'm not cutting corners for him.
So if we stay, we can't be part of his.
At circuit court, correct, yes. Is there a testimony?
Rights of some sort?
You said what?
Is that a restriction of some sort of a right or something, I would think?
No, that's just the testimony. You cannot hear testimony of other witnesses and then testify afterwards. No, witnesses are sequestered for a reason. They keep their testimony pure and not made up. So if you're going to, I'm gonna ask you again, everyone to leave. Like I said, I don't know.
None of these people will be witnesses there.
Okay, well, I'm gonna get all their names for the record. So sir, right there in the shirt, stand up.
Yep.
You, what's your name?
I'm known as Michael.
Michael, what's your full name?
By hearsay, it's John Michael Hayes.
That's your real name, John Michael Hayes?
It's hearsay. I don't know. I wasn't there when I was born, so I came out and I don't know.
All right.
I'm just known as, I've been known as Michael for all my life.
Sir, what's your name? Is the next one?
Norman James Valani.
Norman James Valani?
Yeah.
All right. Sir, what's your name? Here, long hair, stand up. No, back row. Sit down, sir.
John Davis.
Say it again.
Christopher Davis.
Christopher Davis. All right, sir, back there in the corner, blue shirt, what's your name?
My name is Michael Lewis.
Michael Lewis. All right, sir, right here in the front row with your black shirt, what's your name?
Robert Vogt.
Robert Vogt.
Vogt.
Vogt, V-O-L-T-E.
VOGT.
Oh, B-O-G-T, I'm sorry. All right. Ma'am in the back row with the black and white shirt, please stand and raise, please stand. State your name.
Christine.
Christine Marie. All right, and behind you, what's your name?
Carol T.
Carol G. All right, so all your names have been preserved for the record. If you leave now, I will say these people have left, but if not, you take a testimony, you cannot testify at circuit court. All right. So you may call your first witness, Mr. Van.
I do have two other preliminary matters, Your Honor.
Okay.
First, I did notice when I walked in, I believe that several members of the audience had cell phones and or recording devices. I'll just ask that under the court rule, the court instructs all members of the audience to keep their phones away unless and that no recording is permitted in this court without prior permission from.
Right, there's no recording. If you record, you'll be asked to leave the courthouse. It's that simple. We'll ask you to leave. If you don't leave, then the officers will remove you by any means necessary. Next.
And then the final preliminary matter, Your Honor, under MCR 6.005, defendant does have the right to represent himself. However, I would ask that you do make a record of his choice to do so, understanding the consequences of representing himself moving forward, and touching on People versus Anderson, which if the court needs to cite, I can pull one up, but just to understand the full scope of representing himself, and his waiver of having an attorney represent him today.
Any other preliminary matters?
That is all preliminary.
All right. You may, Mr. Prentice, as stated, you had an opportunity to have counsel here. You chosen to represent yourself. Is that correct?
Yes, I'm here on behalf of the state to represent the state.
All right, and understand that you're swimming by yourself. I'm not going to sit up here and say, you need to do this, you need to do that, you chose to represent yourself, so you have to do it to the best of your ability, understand?
Actually, Your Honor, I don't understand any of the nature of the cause.
Well, please stand when you're addressing the court.
I do not understand the nature of the cause of that, so, as far as that we've been through so far, there's been no pleading on my behalf or the estate. There's, numerous questions, as I understand it.
Okay.
Hold on, excuse me.
I just said, okay.
Okay, thank you. This is an exam hearing for me, allowing me to examine all the facts that have been brought against the estate. Am I correct on that?
It's a foreign examination where the prosecutor has to put on proof that a probable cause standard that this felony crime charged against you was committed in this city of Pontiac, and that you were the person who committed it. So they're putting on evidence. I'll make a determination, whether or not this case moves on to circuit court.
And do I have the opportunity to ask also?
You do.
Keep in mind.
That's what I'm saying. You do, you have the opportunity, but
Thank you.
I'm going to direct it. You gotta ask open-ended, questions.
Sounds good. Thanks.
Are you making some?
One more, just so the record is clear, so the defendant is aware, the charges today are against Glenn Michael Prentice in his personal capacity. This is not a civil case, it's a criminal matter. There are no charges against any state. So I just want to make that clear for the record and for the defendants.
All right. So understood. You may proceed.
It will call Craig Jones.
Right. Do you swear or affirm subject to the things given as a perjury testimony given this court be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may proceed.
Good afternoon. Could you please state your name and spell for the record?
My name is Craig Jones, CraigJones.
And where are you employed?
The Oakland County Register of Deeds Office,
And how long have you been employed there?
just over 4 years.
And what's your job title?
I'm the Chief Deputy Register of Deeds
And where is your office located?
in the Register of Deeds office at 1200 North Telegraph in the courthouse.
And that's in Pontiac, Michigan.
Yes, sir.
And when some sort of housing dispute or redemption matter related to a foreclosure of a home arises, can the Register of Deeds office act as some form of a liaison between those two parties in certain circumstances?
We can accept funds for deposit for redemption process.
And is that how does that process typically play out? What does that look like?
We would receive the funds along with redemption memo or affidavit stating the amount that it should be, and then we deposit it with the treasurer's office.
And are you, at least on a surface level, familiar with a foreclosure that occurred or that was occurring involving a property located at 6183 East Holly Road in Holly, Michigan?
I'm aware that, yes, that was going on.
And did your office become involved in that particular redemption process?
Documentation was sent to us and we received it.
I'd like to direct your attention to October 28th, 2024. Do you recall that date?
Yes,
Were you working on that date?
yes.
Did you receive anything unusual while at work that day in the mail?
We received a package of some documents along with a check.
And what, if anything, was unusual about the contents of that package?
It had more documentation we would normally receive for a redemption check, and the check didn't look like a normal redemption check we would receive from like a certified check from a lender, or on behalf of from a bank on behalf of a person.
And what stuck out about the difference, and what stuck out to you about that aspect?
Yeah, again, there was ample documentation that was received with the check that was unusual, and the check, I believe it had individual's name on it. Again, instead of like a bank or a lending body to have the check where the check would be from.
And what name was that on the check?
I would have to look at it again, but I believe it had Glenn Prentice's name on it.
And do you recall who sent, who was labeled on the envelope at the center of that package to your office?
Well, it came from Glenn Prentice to us. It was a certified mail envelope.
And have you seen an individual by the name of Glenn Prentice before?
Yes, sir.
Would you recognize him?
Yes,
Do you see him here in the courtroom?
yes.
Could you point to him and describe what he's wearing for the record?
He was wearing a blue shirt, sitting there at the defense table.
Yeah, the record reflected the witness that identified the defendant.
So no,
Would you recognize the check that was presented to your office in that package?
Yes.
Your Honor, at this time I'm showing defense proposed exhibit 1. May I approach the witness?
you may.
What about this evening?
A copy of the check that we received?
Is that a fair and accurate copy of the check that you received in October of 2024 from the defendant?
Yes, sir.
Does it appear to have been altered or tampered with from the state it was in when you received it?
No.
Your Honor, at this point, I would move to admit and publish proposed exhibit 1.
All right, Mr. Prentice, Mr. Valencourt just showed you a picture of a check. Do you recognize that check?
I recognize the negotiable instrument, Your Honor.
Check, negotiable instrument, all the same. Did you recognize that?
I recognize the negotiable instrument.
All right, and, are you objecting to it being admitted into evidence?
I object that it's being referenced as a check.
Oh,
It's not a check, it is a negotiable instrument, there's a distinct difference, sir.
I went to law school and I understand the difference. We have to study it to pass the bar exam. People's exhibit 1 admitted.
Thank you. Was anyone from your office able to cash or deposit that check?
No, we called the sheriff's department when we saw it because we had some questions about it.
So you were suspicious immediately upon seeing that?
Yes, sir.
Okay. And did you ever speak to the defendant himself about this check?
I believe we had phone conversation shortly after that.
Did he identify himself on that phone call?
I believe so.
And did he admit that the check could not be run for deposit?
I believe Mr. Prentice made statements that it wasn't to be deposited. That was for negotiation purposes.
And did the package that you received contain more than just a check? And did you receive other documents besides just what I'm giving you today?
Yes,
And did any of the contents of those documents lead you to believe that you should have been able to deposit that check?
yes, although I'd have to look at the documents again to be familiar with them.
Your Honor, may I briefly take a second and grab another potential?
That's fine.
Would you recognize a copy of a letter that you received as a part of that package?
Yes.
Showing defendant proposed exhibit 2. I will go over that. It is not yet marked. I will mark it as soon as I do.
There you go, sir.
May I approach the witness? Handing the witness proposed exhibit 2. What did I just need to?
A copy of the letter that was received with the check and the package that we received.
Does it appear to be a fair and accurate copy of that letter you received?
Yes.
Has it been altered or tampered with in any way to your knowledge?
No.
I would move to admit proposed exhibit to publish.
All right, those documents you just were handed, Mr. Prentice, do you recognize those documents?
Your Honor, for the record,
Please stand when addressing the court.
I'm
I'm
objecting.
deaf, I'm
that-
deaf when you talk and you don't stand.
I apologize.
All
I
right.
object that this is kept referring to as a check when it is not a check.
Sir, we're not even talking about the check. We're talking about the documents you were handed. Do you remember the I'm past the check, negotiable instruments, piece of paper.
Thank you.
Do you recognize the documents you were handed?
I do.
All right. Any objection to the amendments into evidence for the record?
Yes, that's fine.
Admitted.
Before I continue, I just want to make note for the record, I do believe the defendant has a cell phone that is recording on the table.
Okay, so at this point, if you're not an attorney with a license, please hand your cell phone to one of the court officers or you can leave my courtroom. And I'm not gonna repeat myself. So if you have a phone, after I told you to hand your phone to the officer, you'll be held in contempt of court. Except Ms. Kazmaka, she has a bar license. She's okay. The two ladies in the back, please give your phone to, I don't care. Don't argue, don't talk, or you can step out. Over here, is everyone phone? All right, we can put them somewhere they.
No, right here.
We have our own. Are you fine, sir? You could have this phone. All right.
All right, taking a look at exhibit 2, which has now been admitted. Could you take a look at paragraph 2 of that letter and read for the court the second line of that paragraph?
Yes. Paragraph 2 says, I have to have the ability to process secured transactions using lawful U.S. currency. Today, the remedy is collected at 31 USC 5118D12 to discharge all your liabilities by your birth certificate banknote bond, which you covered into your minor account 31 CF.
Sorry to interrupt. Is that from the paragraph labeled as paragraph 2? Are there numbered?
Yes, that is number 2.
May I approach them?
You may.
Make sure I didn't read it wrong. I apologize, Your Honor. I'm referring to the incorrect paragraph. Could you please take a look at paragraph number 4 and read the second line of that section?
The second line.
Or the second sentence.
Yes. I provided you with U.S. currency in the form of a negotiable instrument that can be deposited to your bank as a negotiable instrument with specific instructions on how to handle the instrument.
Thank you. Did the package that you received from the defendant contain any additional documentation regarding this redemption payoff amount for the property in question?
Yes, there was a redemption letter along with the rest of the documentation.
And do you happen to recall either the exact amount or roughly what the amount for that redemption payout was on that document?
The amount was just over $264,000.
And what was the dollar amount on the check that you received from the defendant?
$265,956.65.
And just to be clear, was anyone from the Register of Deeds office ever able to cash or deposit that check or document that you received from the defendant at any point in time?
After we called the sheriff's department, we did not attempt to deposit the check because it was deemed not depositable, not valid.
I have no further questions. Please.
Mr. Prentice, you have to ask some questions if you want to for cross-exam, but you have to do it at the podium. There have to be question forms too.
That was Mr. Jones. So this is the second time we've met, correct? Do you remember the first time that we met, sir?
I don't remember the exact date. I know we've met it.
We've only met, this is the second time, I would refresh, we met, 10:16 a.m. July 6th of 2026 at the Open County Register of Deeds.
Your Honor, I would object, I don't believe that is a question.
Right. You need to ask questions.
Okay.
Who, what, when, where, how. You have to end with a question.
Remember meeting July 6th, 2026, when I filed a notice with the Register of Deeds. There was a gray haired lady standing there, and we had a brief discussion.
Yes.
Thank you. At that discussion, do you remember me saying to you, you said to me that I'm different to you, and I had said two exact words. That cannot be because this is the first time we met. Is that correct?
Objection, and that's hearsay.
He was there.
All right, sustain.
Do you agree that that was the first time? Correct.
I believe we've met before in the Register of Deeds office, but I can't remember the exact date.
Very. From, I do have a question for the assistant prosecutor, Your Honor, is that okay?
You can ask them off the record. If you,
Okay, off the record.
you can, I mean, a question, you can ask them, you whisper in his ear, say, hey, I don't know.
I need clarification. As I
Hold on 1 second. Go talk to him quietly.
This packet here. That I picked up from the prosecutor's office. Also, we go to ACU. For administration. They agreed, and your office said this was for the. So nothing.
Sparling with that public stories. Anything that I have as a sense would have been included in that package.
Thank you. I just wanted to clarify. So I have read through the prosecutor's package. Which, as I understand it, and correct me if I'm wrong, but it appears that the victim in this, the Craig Jones, is that correct? Are you the victim here? As I read here, if I've not made a mistake, there has to be a victim, and it appears that the victim even. Yes, if the complainant is Craig Jones, that would be the victim. Is that a correct statement?
I mean,
So, then
Your Honor, I would ask
some question.
I believe the defendant or the defense is calling for a legal conclusion from.
Can I approach Your Honor?
Right, it's not the victim. They could have wrote his name in, they could have wrote in the register of deeds. I mean, he's just the employee of the register of deeds, so he was the person who responsible. So he would be the best person to testify as to what allegedly occurred.
Okay, so
So that's why his name is on the complaint.
may I approach
What are you approaching
with prosecutor's evidence?
to refresh the recollection? You just can't approach with documents there.
I just want to make sure that he sees that his name is not signed anywhere.
I don't see
I
how.
don't see a Jones sign on here.
Okay, that's fine. Let's move on with the
Okay, so
question.
Your Honor, my point is,
No, there's no point. Ask questions about the uttering and
it
punishing.
says the complaining would,
We don't care about all that. We care
or it says the
about,
complaining witness's signature is blank here, but it was never signed by the complaining witness. So,
you're looking at the complaint. I signed the complaint. The officer signed the complaint. I signed the warrant. That is irrelevant. Let's get to the uttering and publishing. Let's talk about the check or negotiable instrument.
well,
Let's talk about that.
the instrument itself.
Well, let's ask question to Mr. Jones. This is why we need attorneys.
No, Your Honor,
This is why we need attorneys.
Your Honor, I understand, but the nature and cause of this entire thing, you guys are moving forward on the fact of what the prosecutor's admitting here. We don't
They
have,
have the right to press charges in the state of Michigan.
I've never
The
received a warrant.
prosecutor can, press charges. They can do that,
They can do that, but there also has to be a signed warrant.
which there was, because
That's
I signed it. I looked at it. I was like, oh, I remember this case. I swear to, I signed it back on March 17, 2025. Last time I checked, I was a judge. So let's get to the othering and publishing. If you need a timeout to go in the hallway to recollect, please do
I
so.
don't.
Because this exam is gonna be done
I
today.
don't need to recollect.
All right, so let's talk about the uttering and publishing. Let's get to the check. Let's get to that, or
There's
negotiation.
no further questions for Mr. Jones on that, but I do have other questions regarding.
All right, so you have no other questions about the check?
Regard to, so the fact is that we've met the one time. The fact is that there's been no issues between him and I.
I don't understand how that goes to the charge of being other and publishing as
Your
true.
Honor, Your Honor, I've asked repeatedly when I was picked up, I asked in jail, Mr. Here, I've not seen a warrant, Your Honor.
Mr. Prentice,
Yes, Your Honor.
you were advised of the charges at arraignment. You were advised, you have the complaint, you know the charges. Whether you want to accept to believe the charge against you, that is not my problem. You've been advised of why you're here, and we're trying to get to the point of the other and
Is
publishing.
there, Your
I'm
Honor,
trying to make a determination today whether you go to circuit court
I have,
or the case
I
gets
just
dismissed.
see the warrant, Your Honor.
You have the warrant.
I don't have the warrant, Your Honor. This is what I was told, Your Honor, if I may approach.
You may not, stay right there.
This is what I was told by the special investigator at the prosecutor's office, that this was the warrant. I said, are you sure? He said, yes. I then went to this court here, to the court administrator's office. If Michael McLeod was not here, I met his assistant, who I have his card. He verified that this was the warrant. What I have here, all I have here in my hand is, Mr. Villan, how do I say it? Valencourt. I have Valencourt's signature, no signature. I have no judge's signature or anything. I have nothing here.
This is the complaint. and
But
the
this was given to me, Your Honor.
This was, okay, well, this was in my file, and I authorized this complaint, it was on March 17th of 2025. And we also have the recording if necessary. So let's get to the other publishing, or I might have to ask you to take a seat.
I am done with Mr. Jones.
All right. Any redirect?
No redirect.
All right, Mr. Jones, you may step down. You're free to leave, Mr. Jones.
Thank you, Your Honor.
People call, Deputy Theodore Ryan Dress. And, my officer charge is retrieving from those home. Then Mr. Jones, please vote.
Back to the prosecutor.
Please raise your right hand. You swear or affirm subject to the pain and influence of perjury, testimony given is correct, be the truth, the whole truth, and nothing but the truth.
Yes, Your
All
Honor.
right, you may be seated.
Good afternoon. Could you please state your name and spell it for the record?
Yep, first name is Theodore, last name is Reindress, RHYNDRESS,
And where are you employed?
with the Oakland County Sheriff's Office.
How long have you been employed?
Roughly 23 and a half years.
I'd like to direct your attention to October 28th, 2024, at about 3:30 PM. Do you recall that date and time?
I do,
Were you working on that date and time?
I was,
And on that date, did you respond to a call from the Oakland County Register of Deeds office?
I did,
And was that in Pontiac, Michigan?
it is.
And who did you meet with when you arrived there?
Mr. Jones, supervisor of the deeds office.
And what did Mr. Jones provide you with when you arrived?
He provided me with some documents of what appeared to be looking like checks and some emails and stuff.
And would you recognize a copy of that check?
Yes,
May I approach the witness?
You may.
Approaching with admitted exhibit 1. Is that the check that you reviewed that day?
it is.
And what observations did you make about that document?
Just looking at the check, how it said certified funds, some of the language on it. The way it came from also an LLC and the amount and stuff just didn't seem normal, I guess you could say.
And were you able to conduct an investigation into the information on that document?
I was.
And what did you learn about the numbers and figures that were on that document?
The document, the check, actually in the thin blue lines or the lines there, using a loop, which is a magnifying glass that actually lets you read what's in the lines in the checks. They have writing in there, and in the writing on the thin blue line on this one said microprint. And then also I used app called, or a Google search for, it's called bankcode.net. And what that does is you can put in routing numbers or account numbers to see if they come back legit or not. And as I did that, both the routing and the check number came back with negative results.
And what's the significance of, you mentioned you read microprint, what's significant about that?
So the microprint on if you're printing checks and whatnot, in your thin blue line or in the lines around the checks, there's writing in it. And what that indicates is that it's a legit, or it could be a legit check, because when you print them off from a copier and whatnot, it's only a solid blue line. So the banks do it for a kind of a security feature.
And during the course of your career as a police officer, you received some amount of training into determining whether a document is legitimate or not.
I've had some detective training, yes.
And were you able to use that training and experience to make a determination as to whether or not the check that you examined that day was in fact legitimate or not?
I was.
And what conclusion did you come to?
The conclusion I came to is that it appeared to be fraudulent.
Was it your determination? Were you able to determine whether or not that check could have been deposited or cashed at a bank?
That I could not.
But you were able to determine that the document itself was not a valid check.
That is correct, just by some of, again, with the wording and some of the writing, it did not look authenticated or right.
Based on your training experience, would a document that was determined to be an invalid check be able to be deposited for cash at a bank?
It should be no.
I have no further questions.
Cross exam.
Yes, sir. I didn't run fast. I couldn't get Steve. How do I spell your last name?
Rhindress, it's RHYNDRESS as in Sam.
Thank you. Mr. Rangers, I'm using this certified funds from the prosecutor's office. Can I approach him with show this document?
That was admitted to evidence, that's fine.
Absolutely. Looks like you have a copy there.
All right, go back to the podium and answer questions you need to answer.
So looking over this, on the top left, where it says payable through, you see Glenn Buckner Senior. What does it say below that?
It says done in good faith and honor.
Who was the instrument addressed to?
I'm sorry, can you repeat the question?
Who was the instrument addressed to?
It says Utica County Circuit Court.
Do you see anywhere on that instrument that was addressed to the Register of Deeds?
I do not.
Thank you. You also noticed that there was writing underneath that, or a memorandum explaining the nature of the instrument, and what it lays forth, and its purpose per federal law.
Are you referring to the reference?
It says underneath there, it says memorandum, this note must be processed, deposited as an emotional instrument. Do you see that?
Yes.
Oh, I'm sorry, yes, I was looking at the check. I do see what you're talking about now, the part underneath the check, yes.
So, on we're talking, this was submitted as a three-part instrument, much like when companies or other people doing business, as you quote unquote call them, a check, they have to remove a proportion. You understand that?
Yes,
Okay, so this removable portion was included with the instrument, explaining everything in detail about this. And it also, it clarifies in here, exactly what, did you research any of the information on the memorandum that was submitted to it? Or were you particularly just looking over the top portion was 265,956.65 amount? Did you actually research every statute, code, and law in this memorandum?
that I did not know.
You did not do.
I didn't look at every statute code
So you,
down in the memorandum, no.
without doing due diligence on the memorandum portion of the instrument that was attached, you concluded that this was fraudulent or bogus, quote unquote, check, as you said.
That is correct.
So you did not do proper due diligence.
Again, looking over the check and then with what I had and what I was going with, I looked at the check. That's what my focus was on.
Right, sir, I understand what I'm saying, but as I said earlier, when you have a three-part, and we can use the term here since Judge Bowie is our second, he understands the negotiable instrument check, even though they're not reversed. Interchangeable, under any three-part instrument or check that is submitted, the memorandum is the portion for the records. And so the memorandum portion explained the nature and purpose of this negotiable instrument. It did not.
You have a question?
Yeah, the question is, and I just want to be sure that Mr. Theodore, Officer Theodore, I just want to make sure, with the record, that you did not take the time to understand, read, or process the memorandum that orchestrated this instrument. That is correct?
That is correct. I did not look at all the statutes.
All right, can you redirect?
No redirect.
All right, Deputy Ryan, should ask you to step down.
The people rest.
Okay. Okay, so. Any witnesses on behalf of Mr. Prentice?
I'm sorry, Your Honor, I sorry.
Any witnesses on your behalf for this exam?
I have, actually, I would like to, I have questions for the assistant prosecutor on what was given to me. And I also have questions, I have a question for this court.
Mr. Ryan, Mr. Prentice, I need you to answer the question I'm asking. The prosecution is resting. I'm asking, do you have any evidence you need to present?
Yes, I do, Your Honor. I have evidence to present.
Do you have witnesses you want to call?
I don't have witnesses. I have evidence that is,
So hold on. You can only get evidence through witnesses. So you're not presenting the case. So you're resting, is that correct?
no, I'm not, Your Honor. I have a very key question, Your Honor, as.
I'm trying to be patient. You can only get evidence. So evidence in court is not questions. It's the answers from the witnesses and the exhibits. The questions that attorneys ask are not evidence. We instruct jurors on that. Do you have witnesses you can ask questions to get answers, which is evidence?
The
No.
only witness that I need, who's not here that I know of, is Court Administrator Michael McLeod.
Well,
Because I filed,
so you don't have any witnesses. He wasn't subpoenaed. So I guess
I
you're
did not
arrested.
subpoena, Your Honor. The fact is that there was a motion filed with this court October 20th of 2025 that was not put on the register of actions. It was served, certified mail and received. It was conveniently left off the docket. And what I'd asked for is that we revoke and revest the securities of this matter, because this is a security trust matter, and it was avoided. But also, the prosecutor's office received this very motion, and nobody responded, and nobody said, and on the register of actions, on the register of actions, it also included a call asking for a hearing date on this, and it was not provided. So evidence was hidden, which is exculpatory. And that's it, and I have more stuff to cover,
But I'm asking you, do you have witnesses to call? The
I
answer is
have
no.
witnesses, I have evidence to submit.
All right, so, well, you're done. Motion to
No.
bind over. Yeah,
Well, that's what you said.
You're actually finding that the burden of proof in this matter, we have met the elements of the offense uttering public, as the violence matter over to the circuit court.
a response to his motion to bind over, Mr. Prentice?
I do not consent to that, but you apparently want to do what you want to do. The fact is that, I am going to appeal these decisions. And I will be referring this to federal court. I will provide, notice of intervention, that I will be filing downstairs. I will have it with the first copy, and I will give you a copy. And I will file a copy with the clerk when I leave here.
So as to his, motion to bind over, response to that motion to bind over?
Because I object. I do not consent.
See.
I have not seen evidence, Your Honor. I have not seen no signed warrant. I'm not seeing a sworn statement.
Mr. Prentice, I feel like if we show you a signed warrant, you're still not gonna go do something else, so. Is there anything else you need to say before I make my decision?
Your Honor, I had asked him off the record. The prosecuting attorney, I asked him off the record if this was everything. Everything was given to me. Nothing was signed. I do not have the evidence. You want to bind over to a circuit court case, you have been not providing evidence. I also have 11 blank pages with barcodes from the prosecuting attorney's office that I would like to know was on those blank pages. I have a myriad of questions. If you want, I would like to put the assistant prosecutor on the stand and ask him questions throughout the package that he gave me, and they're denying me the evidence that you want to try me for. So yeah, I have a lot of questions, Your Honor. Well, it seems like you want to move it the way you want to move it, to bind this over to the Sixth Circuit. But the fact is the prosecutor is withholding evidence from me,
All
and
right, well,
I'm not seeing it. And I do not understand the nature and cause of these charges here. And the fact that T-Land is on the prosecutor's office and he's not here for testimony today is kind of troubling. Because even in his paperwork, he saw no actionable offense against me. And yet, he's not here to examine. And he's top of the list of the prosecutor's stuff, he's right on the documents.
okay.
Where is he today, please?
At the exam, they can call whoever they want to call. This is not trial. Once again, Judge Bowie is not running this the way he wants to. He's running this the way the law says it should be ran. So at the exam, if the prosecutor feels like they can get a case bound over on one witness, they can do so. At trial, you have different rights. So, anything else?
Two things. I would just note, one for the record, the secretary is here in attendance, sitting at the table with me where he's been the whole day. And then two, just, I know that we took names orally at the beginning of, today's proceeding. Could I make a request before that we check driver's licenses or IDs or just confirm, first and last names? I do believe that there was a number of first and middle names given. And I just want to make sure that we're clear so we don't have, and so there's no issues, that's our request.
And Your Honor, may I request that the 11 blank pages that,
So, no, listen out, I'm done.
you're done?
We, if there's any issues, we do have video camera that you want to pull and review. You know, I guess we'll figure out the proper procedures for that. If you need to identify people who think they want to testify at trial, you're better off if you get a fake name, at least cover your face up, because high definition cameras will catch your face, so. Just let us know. The defendant has been charged with the crime of uttering and publishing. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt: that the document in question in this case was false, altered, forged, or counterfeited in the state prosecution's claim. I think here we have a check or negotiable instrument in Mr. Prince's line that was either forged or counterfeited. We did have testimony from Deputy Theodore Ryan Stress that there was a call for his services at the Oakland County Register of Deeds, which is located in the city of Pontiac. That he recognized, he was given a check. People's Exhibit 1 was that check. He conducted an investigation on that check. And he found that the routing number and account number were fake. They were not legit, off of bankcode.net. He's done that in his experience, his training experience, and as a officer in conducting investigations on fraudulent checks. It came back that the check was fraudulent and that the amount of that check was $265,956.65. That was presented to the Oakland County Circuit Court or the Register of Deeds. This was a real estate transaction. The Circuit Court don't accept checks for real estate transactions because the Register of Deeds holds all deeds to properties within the county of Oakland. I think a little of research would unveil that fact. Second, that the defendant represented either by words or action or both that the document was genuine and true, and offered it and presented it. I mean, obviously, he wrote a check out. He presented to the Register of Deeds. It was to redeem a foreclosure. So his actions and his words both indicated that he wanted that check to be used to be cashed to take care of his property that was foreclosed on at 6183 East Holly in Holly, Michigan. I think that second element is met. The third element, the defendant did this when he knew that the document was false, altered, forged, or counterfeit. Mr. Prentice knew that that check was not drawn on a bank or a financial institution, that when he presented that check will not been able to get cash. And so he understood that that check, when presented, was forged or counterfeit. And fourth, that he did this with the intent to defraud or cheat someone. And I think that element is met as well. Presenting a false check to someone, knowing that there's no money or it's not drawn on a financial institution or that check will come back bounced, is showing a specific intent to defraud or cheat someone. So I think that people have met their burden of proving probable cause as to all four of those elements of uttering and publishing. And Mr. Prentice is bound over Sixth Circuit Court as charged for further proceeding. His bond is continued. His arraignment date will be 10 to 14 days from today. The Circuit Court will reach out to you, Mr. Prentice, and let you know you're all set.
We're gonna go do it out of the court.
Thank you.
Out of the court. Do it outside of the courtroom.